ICE has been conducting raids in Los Angeles and other areas within Southern California looking for undocumented immigrants. A federal district court judge in Southern California said, "Well, what you're doing is constitutionally deficient and you need to stop." Yesterday, Monday, September 8th, the United States Supreme Court put a stop to that decision by the district court judge and said that ICE could continue. Justice Sonia Sotomayor wrote a dissenting opinion. People asked me to talk about it, so let's do that. The case is called Nome versus Perdomo and others. Here's some background. In June, the government launched immigration enforcement raids across Los Angeles and surrounding areas. Teams of armed and masked agents pulled up to car washes, tow yards, farms, and parks and began seizing individuals on site, often before asking a single question. A federal district court judge found that the raids were part of a pattern of conduct that likely violated the Fourth Amendment. What does the Fourth Amendment say? Well, in part, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And arresting a person is certainly a seizure of a person. The district court, based on evidence that was before it, said that the government was stopping individuals based solely on four factors: their apparent race or ethnicity, whether they spoke Spanish or English with an accent, the type of location at which they were found, such as a car wash or a bus stop, and the type of job they appeared to work. This, according to Justice Sotomayor, is a violation of the Fourth Amendment, and rather than stand idly by while our constitutional freedoms are lost, she dissented. She went through some of the things that have been happening, some of the people seized, including United States citizens who happened to satisfy all four of those criteria. After looking at that evidence, the district court entered a temporary restraining order that said, in relevant part, as required by the Fourth Amendment of the United States Constitution, defendants, the government, shall be enjoined from conducting detentive stops in this district unless the agent or officer has reasonable suspicion that the person to be stopped is within the United States in violation of U.S. immigration law. In other words, comply with the Fourth Amendment. And defendants, the government, may not rely solely on the factors below, alone or in combination, to form reasonable suspicion: apparent race or ethnicity, speaking Spanish or speaking English with an accent, presence at a particular location, or the type of work one does. You could add additional things to those four, but those four by themselves are not enough. The government appealed to the Ninth Circuit and moved for a stay pending appeal, meaning the Ninth Circuit was asked to say, ICE can continue doing this because the district court judge's ruling is stayed or stopped until there are further proceedings. The Ninth Circuit said, no, we're not going to do that, and noted that the government chose not to dispute that these detentive stops have been based solely on the four enumerated factors. So they're only using those four things to decide whether to stop somebody. Sotomayor noted that the government and Justice Kavanaugh, who wrote a concurrence, has all but declared that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work and held until they provide proof of their legal status to the agent's satisfaction. But, Sotomayor notes, according to United States precedent, a set of facts cannot constitute reasonable suspicion if it, quote, describes a very large category of presumably innocent people. She notes the Fourth Amendment prohibits exactly what the government is attempting to do here: seize individuals based solely on a set of facts that describes very large category of presumably innocent people. Without even a citation, the government asserts that 10% of the population in the Central District of California is unlawfully present. That ignores the fact that 47% of the Central District's population identifies as Hispanic or Latino, and over 37% of the population of Los Angeles County speaks Spanish at home, and over 55% speak a language other than English. Therefore, many people would be caught up in these raids who are United States citizens. So those four criteria are not satisfying Supreme Court precedent and the requirements of the Fourth Amendment. The government tried to dispose of this case on other grounds, including standing, which Sotomayor rejects, and district-wide injunctions, which she also rejects. Getting into whether an appellate court should stay a district court's temporary restraining order, she says an applicant, in this case the government, must not only show a likelihood of success on the merits, meaning winning when you go back to trial, but must also demonstrate that the implementation of the judgment pending appeal will lead to irreparable harm. Well, the government would not be irreparably harmed here, she says. The temporary restraining order does not preclude the government from enforcing its immigration laws, so long as in doing so it stops individuals based on additional facts on top of the 4 factors listed. An example she gives, if there were intelligence that a particular business had been hiring people not authorized to work in the United States because they're not citizens, that would be an additional factor that could allow the other 4 factors to also be used. So it's not the government who is harmed, it's the people of Los Angeles and the Central District of California who will suffer from the court's grant of relief to the government. ICE is seizing people using firearms, physical violence, and warehouse detentions. United States citizens are being seized, taken from their jobs, and prevented from working to support themselves and their families. Another problem Sotomayor has, the court's order is entirely unexplained. What is the district court to do, she asks, when this case goes back for further proceedings, when the district court judge doesn't even know why their TRO was stopped? Was the key issue standing, the merits, the scope of relief? Any one of those things could have been the basis for the majority's order, but the majority doesn't say. Concluding, Sotomayor says the Fourth Amendment protects every individual's constitutional right to be, quote, free from arbitrary interference by law officers. After today, that may no longer be true for those who happen to look a certain way, speak a certain way, and appear to work a certain type of legitimate job that pays very little, because this is unconstitutionally irreconcilable with our nation's constitutional guarantees. She dissented. This case is not over. A temporary restraining order is often just the first step in several steps in a case like this. The case now goes back to the district court for further proceedings, potentially a trial, to develop more facts and to decide if there should be a preliminary injunction and potentially a permanent injunction prohibiting the United States government and ICE from doing these things as violations of the Fourth Amendment. That will then make its way back up to the Ninth Circuit and the Supreme Court, where there will be full briefs if the Supreme Court takes the case, and then an actual full opinion of the court, unlike these shadow docket things. So it's still possible that this comes back and we have more Fourth Amendment proceedings, but for now, we really don't know why the court did what it did, and neither does the judge at the district court.